Richard Smith here at Smith Injury Lawyers. This is our second video. The first video we talked about the need to take photographs to show impact so that your case will not be considered a missed case. That's M.I.S.T, minimal impact soft tissue. There's also another reason to be sure that you take photographs or that you don't move your vehicles prior to the police arriving. I received a call recently from a client who basically indicated that the person at fault, who was a young girl, admitted fault to them, said she was on her phone not paying attention, and then they moved the vehicles before the police got there. When the police got there, they talked to her parents and not to the minor who was driving the vehicle, and they had a different story. So the officer said he could not determine who was at fault because the cars were moved. She's no longer admitting fault. And so the officer didn't charge either party, and now that potential client is going to have a very difficult time getting an attorney, because most attorneys take personal injury cases on a percentage basis called a contingency fee. Lawyers don't work for free, so basically they're not going to take a case on a contingency fee unless they feel pretty strong they're going to win the case on liability. Now that is a very case by case, because if somebody has very extreme, very severe injuries, you're more likely to take a chance on liability if you've got very severe injuries and high damages. But almost no one takes a soft tissue case or case involving no broken bones, no surgeries, if you have a question of liability. And so now that person, because they failed to preserve the evidence and they moved the vehicles, they have no way now of proving liability. And so they're not going to be able to proceed with their case. They're going to be stuck paying their own property damage and their own medical bills. So in my book, which you can obtain a free copy of by going to our website and downloading a copy of it, or you can call the office, and as long as you have an address in South Carolina or North Carolina, we'll be happy to mail you a copy of the book. I think the very first mistake discussed in 10 critical mistakes is failure to preserve evidence. And the example I just gave you is why that's so important. Because if that client had taken photographs or not moved the vehicles prior to the police arriving, it's very likely the police would have been able to look at the vehicles and tell that the other driver was at fault. But when the vehicles are moved, it becomes a he said, she said case, and the police will always determine not to charge either party, or sometimes that they charge both parties. And I'm not trying to throw the policeman under the bus here, because basically I'm getting one side of the story from my potential client who called. But I've seen this many times over the years. If you move the vehicles, you don't take pictures, and there's any way that a person could lie and say the accident didn't happen the way that it actually happened, you find the police have no option except to charge neither party, or to charge both parties if they think both of them made a mistake in the case. Either way, the case now is a denied liability case, which means unless you've got very severe damages, you're not going to be able to find an attorney to take that case on a contingent fee basis. That's why it's so important that you don't make the mistakes listed in this book. And all you have to do is call 300-HURT to get a copy of this book, or go to our website to download a copy. I'm going to do more videos concerning automobile accidents, mistakes that you can avoid, mistakes people make. So please subscribe to our YouTube channel to receive more videos and more instruction with regards to mistakes to avoid in car accident cases.
If you're hurt and can't work, call 300-HURT.